Dr. Reddinger, welcome to Constituting America's Constitutional Chats. We're so happy to have you with us today on our topic, which is the amendment process in the U.S. Constitution, the checks and balances that are in that amendment process. And we're going to turn it over to you for some opening comments, and then we'll go to questions.
All right. Well, thank you so much for having me on. It is very good to speak with you and your team. And thank you for the important work you're doing at Constituting America. What I would like to do in talking about the Article 5 amendment process and its checks and balances is to cover three general points. Number one, the obvious. Number two, the practical. And number three, the theoretical. So I wanted to talk first about the obvious because I suspect there are some things that are so obvious that we tend to forget them. So two obvious things. Number one, the United States of America is a self-governing republic. Therefore, we must amend the Constitution. We the people. We the people are the ones in charge in America, and we therefore can't let anyone else do it either formally or effectively / practically. We the people are the ones who are ultimately tasked with determining what the words of the Constitution are and what they mean. The Constitution is the ultimate long-term will of the American people. Obvious point number two, as by way of reminder, because America is a self-governing republic that revises its highest law through the amendment process, it would be good to understand it. And so that leads us to the practical. Now, the practical point here has to do with the process itself. I would submit that most of the Constitution is actually quite clear, but there are a few places where it's trickier to understand what's going on. And this might be one of those places in Article 5 of the Constitution. How do we, the people in America, amend the Constitution? Well, there are two ways of proposing amendments, and there are two ways of ratifying amendments. The two ways of proposing amendments are as follows. Congress can do it, or the states. According to Article 5, quote, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, end quote. This method is the only method of proposing amendments that has occurred for all of our 27 amendments. Or states may propose amendments. So I would continue quoting from Article 5. It says, or on the application of the legislatures of 2/3 of the several states shall call a convention, end quote. And right now, that means 34 states would need to pass a resolution calling for a constitutional convention. And some of you may be aware that that's actually a process that is going on, has been going on for the past several years, since I believe 2013. And currently 18 state legislatures, I believe it's 18, have passed resolutions calling for a convention. Now, after an amendment has been proposed, and there have been over 10,000 such proposals, I believe, what then do we do to actually put this amendment in the Constitution and make it binding law? Well, there are two ways of ratifying those amendments, of making them law. One is through state legislatures, and one is through conventions of the states. Now, most of the time in our 27 amendments, state legislatures have ratified proposed amendments. According to the Constitution, a proposal may become an amendment when ratified by 3/4 of the several states, referring to their legislatures. Currently, that refers to 38 of the state legislatures in order for an amendment to become law. Or by conventions, quote, or by conventions in 3/4 thereof of the states, as the one or the other mode of ratification may be proposed by the Congress, end quote. So only one of our amendments has been ratified in that second manner by state conventions. That is the 21st, concerning the repeal of the Prohibition Amendment of the 18th. And so in Section 3 of the 21st Amendment, the amendment reads that this article, that what is now the 21st Amendment, shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states. So again, there are two ways of proposing amendments, Congress and states. There are two ways of ratifying amendments, state legislatures or state conventions. Now, that's the process. Occasionally, it may well happen that some of us who are not passionate about civics might forget a detail and have to look it up. What I am also even more passionate about is the reason why. Why does it have to be a little bit more complicated? Why does it perhaps seem unclear? And for that, I would like to turn to some theoretical considerations. According to the American founders, why is it this way? And I'm going to list several reasons. And to my friends here at Constituting America, I'm not seeing a timer right at the moment on my screen, so maybe you can just interrupt me if I start to flirt with going too far. But so again, we're going to move out of what I might call the nuts and bolts of how we change the Constitution to the why. Why is it this way? Let's demystify the process a little bit more. To do this, I would like to refer to the Federalist Papers. Many of you may know that this is a famous series of papers collectively referred to as the Federalist, written by James Madison, Alexander Hamilton, and John Jay to defend the Constitution against its critics so that it would become ratified according to the Article 7 ratification process. Why is it so convoluted apparently at first glance? Well, one theoretical reason why it is a bit convoluted is this. In the amendment process, the American people continue the work of the American founders. Just let you think about that for a second. According to the Federalists, and I think this is maybe Federalist 37 and 38, the American people are responsible for correcting the errors of the American founders. The founders / framers of the Constitution put this together, but Madison points out they did not claim to be half God, like Lycurgus, who is the founder of Sparta in ancient Greece. They didn't invent a new religion that said you have to obey the Constitution. Instead, they looked at history, they saw what worked and what didn't work, they tried to improve on those errors. And so the founders wanted to bring the American people in because in the future there would be things that we too would see need to be corrected. We would learn from history, and we need to continue their work. Now, in effect, what's happening here is that according to Madison, the people back in 1787 maybe seemed more virtuous than they even were because they had just fought a major war and exhausted all of their party animosity. And so they could sit calmly. We cannot sit calmly most of the time. Most of the time there is party division. And so we have these checks and balances in the way so that when we pass an amendment, it almost seems like we are wise, though we might not be. Now, I think I'm getting up against time here. So I have a few other points. We can go into it later if we're over time. But I'll continue for now, Kathy, unless you want me to stop.
Yeah, I mean, if you have a couple more points you want to make real quick, I think we're right at the 8-minute mark about now. But
okay, yeah, I'll go ahead and summarize briefly and go into more detail if I need to. Point number two, theoretical point number two, the amendment process, like the rest of the constitutional system, contains checks and balances. The reason for this is, number one, we must assume that even though the American people must have civic virtue, that we are capable of doing what is evil, what is unjust to minorities. Those people need to be protected. For that purpose, the process is slowed down. By slowing down the process in Madison's constitutional system, in his own thinking in the Federalist, it is more likely that the laws that we pass will be aligned with what is just. Number three, theoretical point number three, the checks and balances in the amendment process help us to respect the Constitution. By making it difficult, more difficult than, say, President Jefferson wanted the process to be, the American people would be more likely to respect and to venerate our Constitution, which protects our liberties. To change it too easily is to lose the lightning in the bottle that was captured in 1787. And it's also something that would make us not respect the Constitution quite so much. Again, I can go into more detail on each of those, but those are my opening comments. Thank you.
Well, thank you. And that was a great opening and one of the best explanations I think I've ever heard of the amendment process, and a wonderful reminder that it is up to we the people. And Janine, I know you've got a lot of questions, so we're going to turn it over to you.
Awesome. Thank you so much. I concur with Kathy's comments that your opening was most succinct and clear and concise. Thank you very, very, very much for that.
Of course.
Yeah, yeah. I love what you said about that we, the people, are to continue the legacy of our founding fathers. Of course, that it seems like duh, as if that's really obvious, but somehow the way you put it, the way you put it was gave us all a bit of a legacy to be a part of the country, and I really like that. I love the amendment process. I also love how I talk about this with the students when I can, when I'm giving speeches, to talk about the two ways to actually amend the Constitution. It's just so brilliant. If Congress doesn't want to do it, the states can. I think that was one of the greatest checks. And as far as checks and balances are concerned, I mean, the amendment process is just really one of the best checks on the government. But then if we were to kind of slice and dice it, I think the fact that the state legislatures, in other words, the states, which in other words means the people, if Congress won't do it, the people can do it through their states, can amend the Constitution. Right. That's another awesome check. I don't know if it's ever been, I know there have been a lot of books written about the behind the scenes and who thought of what, but do you know which founding father or which contingent was really working on this amendment process aspect of the Constitution? Because that's some really brilliant thinking there.
Well, the simple answer is no, I'm not certain. I mean, I will say that one of the major founders who was present for the convention for, I believe, something like the first half of the Constitutional Convention and then went ill was John Dickinson. And, Dickinson is credited with being the primary founder to have pointed out that our states might serve something like the House of Lords. The state and senatorial representation might serve something like the House of Lords in the, what is our comparable, cousins over across the Atlantic. And he really emphasized to a great extent that it's the people, Dickinson again I'm referring to here, the people are sovereign, not the states, and yet the states are part of who we are as Americans, and they're important limits on our power. And so compared with someone like Madison, it was really Dickinson who wanted the states to have a more robust place in the constitutional system. And without knowing the answer, that would be the first person that I would probably look to, would be someone like Dickinson, or someone else who was more of a Federalist figure who nevertheless had a very robust appreciation for the state authorities.
And which would be federalism, in that the states have a say, which in other words means the diversity of this great continent. I mean, really, I think that's why a republic lasted so long, is because we have the states because we're so diverse and we're so vast.
Yeah.
It's been part of the great success. And it's what I feel is a lack of knowledge about this process. Americans don't seem to really focus on that this is a process that can be attained. Everyone seems to think I'm going to vote for the president and that's it. You know what I mean? Or I'm going to maybe vote a time or here and I'm going to wash my hands clean of this. Or laws will be passed in the Senate and that's that. And yet the amendment process, I'd like for you to touch on this a little bit, except for, of course, prohibition, which is also interesting that that the convention was called of the people to make sure that that was overturned. They didn't trust their state legislatures to do that in their ratification process, which for students that are listening, that means where they say yes or no to ratify. If
Right.
you ratify it, then it's a yes. But it's really interesting to me, this aspect of letting the people have their own, call their own convention through the
Yeah.
states. And it's never been done. And I think that people think it takes too long, and it's really not. Or they're not really aware of it, but it's powerful because it's rarely ever reversed. How
Yeah.
can we raise awareness? And a lot of people, by the way, are very scared of this new convention. I'm really not.
Yeah.
I think that it really would be a wonderful check on the current sort of egocentric aspects of the Congress. To
Yeah.
say, well, you know what? Hey, we can check you here a little bit. What are you afraid of the new convention, and what do you think about the lack of American will to pass another amendment?
Well, yeah. Maybe before talking about the Convention of States effort that's going on, I'll address that question of, why do people think that it's so difficult, or why is there this ignorance um, about the process itself? And I would say that a primary reason, as I understand it, is, that may sound a bit dramatic perhaps, but I'm concerned at times that some Americans increasingly do not think enough as Republican citizens, in the sense that we, in fact, are in charge of these of our fundamental law. And something that goes along with this is that, I would be concerned as an educator in particular to really encourage students to realize that this is something that we have the power to do. And it's really just not too hard to pass an amendment, I would say. It is difficult, and I would even be willing to entertain the idea that maybe it's a little too difficult. But I don't know that it's really just too difficult simply. Part of the difficulty is that I think that to a certain extent, some of us have effectively outsourced our responsibility to amend the Constitution, in some cases, to other departments of the government. And so, one of the reasons I would suggest why, there haven't been as many amendments that have been passed relative to earlier decades, there's not been one in the 21st century, is that much of our political effort has gone into making sure that people on our quote unquote team are appointed to the Supreme Court. And the clearly that's very important. Although I don't like the idea of thinking about the Supreme Court as being on someone's team other than the American people. It's a kind of referee institution, not a political institution. But what I think that suggests to me is that increasingly people might at times want to be told what the meaning of the Constitution is, or to have it changed to make it new, bring it up to the times by a Supreme Court decision, as opposed to bringing it up to the times through the Republican constitutional means that are laid out in Article 5. And so, it's our responsibility to do this. And so, to a certain extent, it's an educational problem. People must be assured that it is not only the Supreme Court who looks at the Constitution and thinks about its meaning. It is ultimately, in a self-governing republic, it's the people, it's the American people, though all of our departments of government have a responsibility to do this. So I would say the fact that Article 5 is a little bit trickier than some parts of the Constitution is not the main reason why it seems that it's difficult to amend the Constitution, or that it's too difficult. Now, about the Convention of States effort, this is something that I would say, as far as I understand it, I would agree with you that this is not something to be feared, largely because of the constitutional checks and balances and the procedures that we're talking about. Once a convention comes together, proposes these amendments, just as the Bill of Rights, the first 10 amendments, all of these would have to be then ratified through one of the two ratification means that we've already mentioned. And so there are all kinds of checks and balances. But, we should say, I think, that this is a debated point. And, what comes to mind to a certain extent is, the concern, Madison said over the Article 7 ratification procedures of the original Constitution. He called it the something like the most plausible criticism of the constitutional the Constitution that had been proposed, meaning that strictly speaking, according to the letter of the law, the Constitutional Convention was tasked with improving the Articles of Confederation, and to do so according to the Articles of Confederation with a unanimous vote of the states. And of course, according to Article 7 of the US Constitution, something like a supermajority, I believe it's 9 of 13, would be taken to be a unanimous vote. And so, to try to counteract some of these concerns, President Washington, of course, famously agreed to go to the Constitutional Convention to put his imprimatur on the proceedings there in Philadelphia in 1787. So, the point being that, one wonders a little bit about whether whether a new Constitutional Convention brought about by the states, would in fact, be bound in similar ways, but it seems pretty clear that nothing would become binding apart from following the ratification procedures that we find, these checks and balances that we find in Article 5. So
Thank
hopefully
you.
that was helpful.
Yeah, it was, and I want to toss now, but I think what I like about what you said is there's a lot of fear. People say, oh, if there were to be another constitutional convention through the states, so to speak, not just to amendment process, but through the states, it would be treated. People fear that it would be like change the Articles of Confederation to the United States Constitution. But I like what you said. It's really more like not changing the Articles of Confederation to the Constitution, but it's like adding the amendments, the first 10 amendments. I think that if you look at it that way, it's a lot less scary. Okay, I'm going to toss to. I'm not scared of it, by the way. I'm going to toss to Jewel. Thank you so much.
All right, it's Jewel Gilbert here with Constituting America, and thanks so much for this masterclass and workshop on the amendment process here. I'm interested, first of all, do you think that one of the two methods is basically, do you think one of the two is better in that it means that the republic is operating in a more healthy way? Do you think that we have not seen a convention of states, but do you think that one of these two ways of amending the Constitution is a healthier way for the republic to enact the political will of the people?
That's a great question. I honestly would need to think about that a little bit more. One of the basic principles that I might refer to is that it seems that at times people develop more self-governing Republican habits when they act like self-governing Republican people. And insofar as a proposal from all of the state legislatures appears to involve a greater number of people, that strikes me as being a healthier, a very democratic type of thing to do. And I love the idea in some sense of bringing about through state petition, state resolutions, a convention, anything that would promote a kind of national debate. People are really thinking carefully about what the laws are that are going to govern them. I think if I were to pick, that's preferable.
Do you think that the founders would have thought that we would have more amendments, less, about the same? What do you think that they would think about the number of amendments that we've had? And not necessarily referencing how long it's been recently since there's been one, but just overall the number of amendments.
Sure. Well, I'm inclined to say that it might depend upon which founder you're referring to.
Maybe it's think about from maybe Jefferson and Adams. maybe from there too.
Okay, sure. Well, Jefferson, I think you're probably aware, he's famously associated with this idea of a pretty regular constitutional change if necessary. He has this somewhat more progressive view of human development and enlightenment. And we, just like we might outgrow our children's clothes, we may well, as a people, outgrow our fundamental law. And, Jefferson is famous for insisting upon having something like a national referendum, or, a national consent to the fundamental law every generation, something like every 18 to 20 years or something. I don't remember the exact year, but that this is anathema to someone like Hamilton, who is very concerned about destabilization, or Washington, who's of a similar mind. I might suggest that one way of thinking about this also would be to think about the debates about the national bank between Hamilton and Madison, in the sense that during some of those arguments about whether a national bank was constitutional, irrespective of whether it's good public policy, part of the argument from Madison, if I remember correctly, is that effectively we can pass laws or amend the fundamental law in very specific ways. And so he's responding there to Hamilton's objection that it's just impractical to change the law a lot. And so I think for some of the founders who would become associated with the Jeffersonians, there's probably an expectation that more amendments or maybe even fundamental constitutional change is going to be more common. And, in a sense, I might think of something like the Texas Constitution. If I remember correctly, it has a huge quantity of amendments compared with many states. And, I would imagine that, Madison might have envisioned something a little bit more like this, as opposed to a relatively small amount. Yeah.
Is there, and I don't know if this is beyond the scope of our discussion, but is there a limit to the scope of changes that an amendment can do within the Constitution itself?
Sure. Well, I guess a few thoughts there. I mean, there's Article 5. What we didn't talk about yet, I guess, is the end of it, which specifically stipulates that no amendment may be made prior to the year 1808, affecting the first and fourth clauses of the 9th section of the first article, referring to the slave trade and to representation as it relates to Black Americans at that time in the southern states. So there's something that's explicitly stated. And so, when 1808 happens, on January 1st, 1808, I believe it was, Congress abolishes the slave trade as soon as it's constitutionally able to do so. Now, having said that, I mean, I think that there are very good questions to ask whether it is a good idea to permit a majority, even if it goes through all of these hoops, to amend the Constitution in a way that's fundamentally at odds with the political principles of the American political order. Majorities have no right as such to violate minority rights. But one might think, for example, of there was an amendment that was pitched, I believe in Lincoln's first inaugural, it's referred to, about the idea that, well, if it means avoiding war, I will agree, says Lincoln, effectively, to an amendment to protect slavery where it currently exists, so that the federal government cannot touch it in perpetuity. And so, I mean, that seems to be a pretty fundamental problem, with political principles. But I think the hope there was that war would be avoided, the Union would be kept together, and internally, states would, it is hoped, through their own Republican process of public deliberation, eventually outlaw that institution for themselves. But But I mean, clearly that's a very fundamental kind of obstruction of liberty.
Yes.
But I don't know that there's any kind of, I don't know that the court, the Supreme Court, or others have spoken in any fundamental sense on that question.
Yeah, it's
So,
interesting
yeah.
because it speaks to me when I think about that. We've on the show covered basically the founding of the country's principles on the different elements of natural law and also like consent of the governed.
Mhm.
And it really
Yeah,
speaks to the
right,
founders' trust in, I guess, the consent of the governed to have such a process of
right,
amendment, saying, well, if they consent to these changes, then they can really make massive, broad stroke changes fundamentally to the Constitution. And I also don't think that they foresaw or wanted like fundamental changes that would change the nature of the documents or the country either.
right,
But they didn't
right.
necessarily say you can't do it. So I mean, we were granted a
Right.
huge amount of power that we don't necessarily use in this amendment process, like in a way that I think that if we had a different culture, you may see amendments being used in a way that are not healthy. You'd see a lot of amendments all the time. As soon as you could get a certain amount of people behind something, that they would just be there would be conflicting amendments. Probably prohibition is the one that we could look to, that we'd have
Sure.
a lot more cases like the prohibition situation.
Right.
And I do think a lot of cultures would produce that. What do you think?
No, I think you're absolutely right. I mean, I don't know that I have much there to disagree with. And I think that's well stated. So, um, the at some point, I think it's a question of why we might have a constitution at all, if the Constitution were to begin to produce amendments which were fundamentally at odds with the whole idea of having a constitution that represents the will of the people. I don't know if that made sense, but
It did.
if you're passing a constitutional amendment, for example, that says, this amendment is it shall stipulate that no state in the union shall have a republican form of government, but shall be a petty kingdom or something. Well, clearly that violates the Constitution's own text, and it violates the whole point of having a written constitution that is changed by the people. And so, but I think you're right. I mean, as you're commenting, I'm reminded of a great little book by Professor Greg Weiner. I'm not sure if you've had him on the show, but this is I think he's now president of Assumption University in Massachusetts, but he wrote this book called Madison's Metronome, and the basic argument is it has to do with time. That the whole system is I alluded to it earlier in my comments, but the whole constitutional system is meant to slow down the political process, and in so doing, it makes it highly likely, not certain, but highly likely that our laws, our amendments, will align with what is in fact naturally just, not just legally appropriate or something. And so I think that's right. In a different process, I think there's no question that we would have more reversals a la prohibition or amendments that we might well look back on and say, that's morally repugnant or something like this.
Thanks so much. I have to pass.
Sure.
Keep asking questions about this forever. And thank you.
Yeah, of course.
Alrighty, thank you, Jewel, and thank you, Dr. Reddinger, for being here and talking about this. It's very well, I mean, I hadn't learned of the state convention or the states calling a convention for an amendment process, so it's still a bit new to me and trying to learn it, and you're doing a great job at explaining it. So my first question is, would you further discuss on how having the states ratify the amendment or the traditional, process when the states have to ratify it after Congress, how that fits into the larger discussion of states versus federal power and the idea of federalism?
Well, sure. I mean, one of the, I guess there's a couple of different ways that we might take this, but one of the reasons why the states are so involved in the constitutional system as a whole and in the amendment process in particular is that I would say that effectively it makes the process more democratic in some sense. So I'll come back to that. But, in our federal system, part of what we're trying to do here is not simply to say, people always bring up Wyoming or Alaska in the Senate. 14 people live in Wyoming, but it gets 2 senators. Sorry, that was a bit offensive to our Wyoming listeners, but I love Wyoming. That's part of the reason why I love it, open space. But Wyoming is a place where it's represented equally in the Senate. But part of what our thinking here is that various interests should be protected. And so it's not so much, like we're doing a math equation when we're passing an amendment or ratifying an amendment. We're not adding up 50 plus 1%. Obviously, we're not adding up 3/4, 75 plus 1%. We're thinking about the most helpful way to dilute central power, and we're thinking about the most helpful way to protect different interests in society. And so politics, there's a great line, I believe, in Federalist 55, where Madison says something like, we can't reduce our politics to arithmetic calculations. Politics is just not mathematics. It takes judgment, the balancing of different interests, and so on. And I think the founders ensured that different interests are going to be protected in the amendment process. And so the point, yes, it was protect state interests, but really the point is protecting different interests and different liberties in different regions of the country as much as possible. The amendment process, as it relates to the states, I would also argue that it makes it in some sense, in a most fundamental sense, more democratic than an alternative. And so, this common objection that it is very difficult to change the Constitution, to amend the Constitution, is one that often is accompanied by the idea that it's unjust because undemocratic. It's so difficult that it's undemocratic. We should be able to pass an amendment more easily through a majority vote. But of course, if you're having a whole variety of interests in a whole variety of regions of the state represented, and that is a supermajority of states, well, that's going to be a larger majority that is going to be agreeing with this law. And so it's really, I would submit, more majoritarian. It's more democratic, at least if we're okay with the idea of acknowledging that majorities can make mistakes, and doesn't history prove that pretty clearly? So hopefully that was helpful for your question.
Oh, absolutely, yeah.
There.
Very, very fascinating point. So we've also been talking about the amendment process acting as, checks specifically on the legislature, and then, with the 22nd Amendment, it acts as a check on the executive branch, or specifically the president, limiting it to 2 terms. How does the amendment process also act as a check on the Supreme Court and the judicial branch as a whole?
Sure. Well, I guess clearly, well, maybe it's not clear. So one of the things that we might well do is that we might see a Supreme Court decision, we the people, and we might decide after a time, that's pretty bad. Let's make it clear that we ought not to agree with that. Because even though the Supreme Court has a very important role to play as a kind of referee of important legal questions, it is not finally and ultimately the determiner of the meaning of the Constitution. And so if there is a decision, the court might make a decision that the American people are persuaded is a bad one. We can respond through a constitutional amendment. So, I mean, that in itself is a fundamental check. And I believe, we might look at a few examples. I mean, clearly the Civil War is a major factor here, but, something like the 13th Amendment, abolishing slavery, is a functionally a legal response to the Dred Scott decision of 1857, which suggested, I think falsely, that the Constitution does protect some sort of right of owning a human being. And the 13th Amendment says no. Slavery is not permitted here except as a punishment for crime. Involuntary servitude. So that would be an example. I think of the, rather more complicated, but the 11th Amendment is passed. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state, which is codified after Wilson writes the decision in Chisholm v. Georgia, which incidentally I think has a lot of important points about popular sovereignty, but nevertheless, it was seen as being something that would endanger state discretion, state authority, and might make the central government too powerful. And so, this is an amendment that is directly against the judicial power. One of the things that it's a bit playful perhaps, but one of the things that I enjoy doing sometimes when questions about judicial power vis-a-vis the constitutional amendment process come up in class is to think about a kind of hypothetical in which the Supreme Court, as it relates to issues of interpretation, there are debates about judicial supremacy versus departmentalism, as it's called. But wouldn't it be interesting to have an amendment that is passed that says something like the ultimate meaning of this amendment shall be determined by the American people and not by the Supreme Court, and then just have a Supreme Court decision addressing that text. So ultimately, I would submit that a kind of power below the level of an amendment is really just related to the issue of other departments of government interpreting the text of the Constitution and the people in everyday life interpreting the Constitution. So, if we can change the words of the Constitution, I'm going a bit far afield here, but if we can change the words of the Constitution in an amendment process, but we still don't have the authority to say what the words even mean, then there's some question about what exactly we're doing trying to amend the Constitution. Determining the meaning of the words has to be part of popular sovereignty and self-government in America. So, those are my thoughts on that.
Well, yeah, thank you so much for your insightfulness.
Sure.
And I'm going to pass it. I'm about out of time, and I see that the audience questions are coming in hot. So I'm going to go ahead and pass it on to Kathy. So thank you so much.
All right. Well, thank you for your questions, Wyatt.
Well, thank you, Wyatt and Jewel and Janine. Great questions so far. And Dr. Reddinger, we've just really learned so much already in this podcast. And we do have a lot of audience questions. Before I go to the audience questions, I want to take a minute and recognize our teachers that are watching today. We have Mary Anastasi on. We have Trent Toller on. We have, we have D'Angela Hines on, and we have Kimberly Sayer on. So if you are a teacher or a student watching and we didn't give you a shout out, feel free to drop your name in the Q&A and we'll say hi to you before the end of the podcast. We also want to thank our listeners in Las Vegas's KKVV 1060 AM on the radio dial. KKVV airs Constituting America's Constitutional Chats on Thursdays at 6 p.m. Pacific. So thank you to everyone in Las Vegas listening. So Dr. Reddinger, we'll start with both Gary Porter and Barbara L. Wanted to make sure that we gave George Mason his due. They said that George Mason proposed the alternative method of having the states empowered to propose amendments. So
okay, thank you.
Thank you, Gary and Barbara, for pointing that out. And Stephen Murray, let's see, as Wyatt said, we have a lot of audience questions today. So I'm trying to go back to Stephen Murray's question. Let's see, here we go. Stephen Murray asks, does all the modern talk about living Constitution confuse people about the legitimate means of changing it in the amendment process? And how do we best clarify that?
Well, I think that, unfortunately, this is wrongly, I think, seen as a bit of a partisan question, and it's really not. But I think the short answer to the question is yes, I think it confuses people. The issue of, living Constitution versus often, contrasted with original public meaning or original intent jurisprudence or something like this, judicial restraint, is one that I think does make it seem as if, well, the Constitution is a crackly old document, and it's clearly old, and therefore, how can it possibly speak to our time? And how can we even know really what the authors meant by it, and so on? Well, I do think it unnecessarily confuses people. There are, I think, serious objections that are raised to certain aspects of the Constitution about whether we can certainly understand it. But even if that is the case, doesn't Article 5 provide us with a remedy? If something is so unclear, we simply don't know what it means, or if we are absolutely convinced that something is outdated, well, we have an Article 5 process for remedying this problem. I think the question really frames it in a pretty good way to point out that by suggesting that the Constitution is too old, it kind of biases us in the direction of saying, well, we need someone to interpret it anew for us, as opposed to, again, we the people being the ultimate interpreters. So, yeah, great question. I think the short answer is yes.
Thank you. And then Chris Ullman asks has some specific questions about how a convention of states would work. And so don't worry if maybe you don't know these, and we could really almost do another whole show just on that topic. But Chris says, can you explain more about the new convention manner of proposing amendments? Who chooses the delegates to the proposing convention? The governors or state legislatures? And will there be an even number per party?
Sure. Well, what I guess I'll say first of all what I know about that. In terms of a constitutional convention brought about by states, I think regardless of the makeup of the delegates, it's important to consider the constitutional provision as it relates to the, and I'm bringing up my Constitution here, as it relates to a state convention. The convention of the several states, I believe I'm correct in saying, will have an equal representation. So it's not as if California can send us 1,000 Republicans and Wyoming can send us 1,000 Democrats, and I switch those up just for fun there. But but rather there would be limits within the structure itself about which state would affirm what. Having said that, in terms of identifying who these are, I would think it's the state legislatures, but I feel certain that someone here, one of our panelists or one of our participants probably knows those details a little bit better than I do. But I would direct you to the very helpful website if you haven't already been there. I believe it's something like conventionofstates.com, something like that, that can be brought up with a quick Google search. They have some very helpful quick graphics to summarize the process. And I'm afraid I don't remember the details very well right now.
Well, thank you. And those are interesting questions and definitely worthy of more research. Andrew K. asked, to what degree is the paucity or lack of recent amendments attributable to the general lack of acquaintance with and understanding of the Constitution? Do you think we've had fewer amendments lately because people are less acquainted with the process and less understanding of the fact that it's available to them?
Yes, I think that is a major cause of it. And, when, if you look into, let's say, 1940s, 1950s on some issues, to a great extent, cultural issues, I would argue that there was an increasing liberty being taken by the court on some questions that, according to some commentators, would be tantamount to a functional constitutional amendment. And so in a sense, to return to what I said previously, there is a kind of outsourcing of our Republican responsibility, in some cases, to the court. So I'd agree with that. Part of what's going on here, I also think, is not simply that people are not acquainted with the fact that we can use Article 5 and what it means. But, I would be in the minority position among political scientists and being pretty open to the idea of congressional term limits. And the reason why this itself is related is that I would suggest that we have, for people who would say, well, the Supreme Court has gotten a little bit too powerful or something like this. We have a number of means by which to limit the power of the Supreme Court, including something like in Article 3, we read that the appellate jurisdiction of the Supreme Court can be limited by the Congress, which is a power that is not often used. And I would suggest that one of the reasons why it's not often used is because many congressmen seem to be pretty interested in re-election rather than wielding power through something like promoting constitutional amendments. And so, I would say that that's, referring back to my opening comments, I would submit that that's an example of an error that Madison didn't quite see. That, instead of ambition, there's something like a desire to continue in office that has taken a lot of the passion of many of our legislators. But by changing up the incentive structure, I think we can incentivize people to realize, well, I'm leaving anyway, let's do what's right and good, this kind of thing. So that's a very distant reason for this, and I can go into that more if we have time, but that I think is an important factor as well.
Well, thank you. And speaking of proposed constitutional amendments that are out there, one of our listeners, Teresa Speak, is active in the Keep 9 amendment to codify 9 members on the Supreme Court. And just wondering if you've heard anything about this effort.
I'm afraid not, but I have to say that it sounds very good. It sounds very good to me. And in part, it sounds very good. I assume you would agree. Don't know, but I assume that, part of the concern has been that there has been this push from time and again to, pack the court, under the Roosevelt administration, or to change the number again in more recent years, really because of policy reasons. And that strikes me as being a terrible idea, not because the number is fixed in the heavens or in the Constitution, but rather because the institutional role of the court is fixed in the Constitution. This is not our legislature. This is a court that should have a kind of agreed upon referee function, and should not be changed willy-nilly for whether they support our policy or whether they support our favorite politician. And so it sounds like a very important effort. So I'll look into that more. Thank you.
Well, thank you. Thank you, Teresa.
Yeah.
And then Francesca Norden says that she looked up that the states were included in the amendment process in August 1787 when the U.S. Constitution was sent to Committee of Detail, but came back without the states and only Congress. Do you have any insight on that, or if that happened?
I'm afraid I don't. I'm afraid I don't. So I'm not really
Okay.
sure what's going on there. Typically what one would do is, there's a few sources, including, Madison's notes and the records of the Federal Convention, and, investigating those might yield some sort of clue about what happened there or why. No.
Well,
Good
thank
question.
you. And then Gary Porter, who is in our audience, was selected as, did you see when Williamsburg, when they reenacted or they had a mock constitutional convention in Williamsburg in 2023?
I missed that.
Yeah, I think Gary was part of that. And Gary said the Constitution places no constraints on the mechanics of an Article 5 convention. The size of a state delegation in the founding period was left up to the state legislatures. So it sounds like it might be up to the state legislatures.
Yeah.
So thank you,
Thank you,
Gary.
Gary.
Thank you, Gary, for that insight. Well, thank you. And we are right at the top of the hour. And so we thank you so much for being with us today. And just
Yeah, thank
such
you.
a great explanation of our amendment process. And we're so grateful to you for taking the time to be on. And we want to thank our
You're quite welcome.
audience for all your great questions. And it sounds like we may need to have another show just on a convention of the states, because there's so many technical questions out there and questions about specific amendments. So thank you to everyone for
Yes,
participating.
and thank you so much. Appreciate it. Appreciate everybody.
Thank you, Janine.
Thank you.
Thank y'all.